Okay. Thank you for coming for this very interesting seminar, which deals with really important issues in the internet era, especially in the context of post-COVID era. So our title today is Sound Internet Policy in the Post-COVID Era and Beyond. We specifically talk about the net neutrality and free flow of information and the Korean and US digital trade. And we have very distinguished three speakers, and also we will have introductory speech by the US Embassy representatives. This event is co-organized by US Embassy in South Korea, OpenNet, and American Law Center of Korea University, and HY Center for Ethics, Law, and Policy of Science and Technology at Hanyang University. And I'm Sang-uk Lee. I'm going to moderate the 1.5 hour session today. And I'm the director of HY CELPST and the professor of philosophy at Hanyang University, Seoul, South Korea. And we will start with the opening speech. And this opening speech will be given by Mr. Michael Cavanaugh. I will give you just a short bio of Mr. Cavanaugh. Michael Cavanaugh is Deputy Economic Counselor at US Embassy Seoul, a position he has held since July 2020. Before this appointment, Michael served as Acting Economic Minister Counselor at Embassy Tokyo. During his Tokyo tenure, he led a dramatic rethink of US-Japan trade policy during when the United States negotiated a bilateral trade agreement with Japan, increased bilateral investment, and expanded cooperation across broad swaths of economic and related issues, including countering COVID-19. Foreign Service Officer since 1994, Michael served as Deputy Economic Counselor at the US Embassy in Cairo in the aftermath of Arab Spring. He also served as Deputy Economic Counselor in Taipei as head of the economic section in Ho Chi Minh City during implementation of the US-Vietnam Trade and Investment Framework, and in Chiang Mai. In Washington, Michael worked as a special assistant to the Undersecretary for Economic Growth, Energy, and Environmental, covering Europe during the Euro crisis, as well as desk officer supporting the US mission to the OECD. He has a BA in history from Yale University. Please, Mr. Cavanaugh, floor is yours.
Thank you very much, and thank you. So maybe your last sentence is the most important. He has a BA in history. So, you know, it really means that I'm not an expert on any of these topics. I'm really here because the topic is very important and very important to the United States and in the US-Korea economic partnership. So that's my informal comment to beginning. Also, today is my birthday. So there's no better birthday present than being able to spend some time with all of you to talk about this very important topic with real experts, not people who have BAs in history, but with real experts who can help inform us in this important discussion. I want to say thank you to Professor Park for bringing all of us together, and to point out like our experts like Mr. Falcon and Mr. Mertens. With those kinds of experts, we'll have a great discussion, and it will all be kept on track by excellent moderating of Professor E. Thank you very much. You know, the internet has grown from a small network controlled by a few researchers to a force for incredible commercial and social opportunity, unlocking value and enabling previously unimaginable advancements in medicine, education, communication, and of course, entertainment. This has been particularly good for Korea. It spawned digital trade, which has become fertile ground for the creative genius of Korean artists, entrepreneurs, and content delivery services. Your music, your television programs, your movies cover the globe. And of course, Korea's tech providers have a key stake in building this new technology architecture. So success in this area depends not only on the content creators and the scientists and engineers. It also depends on enlightened regulators. Why? Because regulators have the power to reorganize the digital trade markets that allow innovation and creativity to flourish, or not. To have new products reach Korean consumers around the globe, or not. For regulators, this is a challenging time. With the tech industry changing so rapidly, how can we best protect consumers? How do you do this in a way that doesn't kill innovation? And how do you do it in a way that does not discriminate or favor one player over another? These are key questions, and there's a great deal at stake. For effective regulation, in our view, a light touch, and openness to input from stakeholders will make the system stronger. Our embassy welcomes further cooperation between the public and private sectors in the US and Korea to foster good governance on the internet. Korea needs to reach consumers around the world, which means that firms have to be able to move and securely process data efficiently across borders. For that reason, it's especially important to adopt international best practices for digital trade, rather than a hodgepodge mix of country-specific standards that inhibit creativity and growth. And as I said, I'm here today not as an expert, but because these topics are important in the context of our US-Korean economic partnership. We talk a lot about the US-Korea alliance, but the US-Korea economic partnership is also extremely important, and it's extremely important to our future. Both the United States and Korea have a strong interest in making sure the internet remains a source of innovation and economic growth. US firms have made huge investments in Korea and in Korean digital content, bringing the Korean wave to new markets and bolstering Korea's soft power abroad. Korean content is having an outsized impact on world culture, thanks in part to a great diversity of delivery channels. How did I watch the movie Parasite? I watched it on Amazon Prime. Furthermore, the longstanding US ROK Alliance and US tech firms' support for best practices on security allow both public and private enterprises in the ROK to confidently employ digital service providers from both sides of the Pacific, that's in Korea and in the US, as trusted partners. By employing international cryptographic standards developed cooperatively by experts around the world, rather than unique and less proven local standards, cloud service providers can compete on a level playing field to offer the most protection at the best value for Korean consumers and consumers around the world. Ensuring open markets for further trade in digital services underpinned by common beliefs in democracy, openness, and free trade will develop yet another important facet to our bilateral economic relationship and Korea's engagement with other countries. That's always been our work, and it remains our work today, especially when it comes to the internet. New innovations in digital trade can support and amplify our shared values. So let me close by thanking you once again, stressing the importance of this very timely topic, and I look forward to the discussion. Thank you very much.
Thank you, Mr. Cavanaugh, for really clear and encouraging, as well as some entertaining speech. And congratulations, sorry, it's more than happy birthday to you. I didn't know this. Okay, we now have three excellent speakers, which will talk about very sensitive and important issues, both in South Korea, but as well as in other parts of the world. And after we listening to three speakers of each of a 20-minute speech, we will have a question and answer time. We are going to collect all the questions in the form of the written comments. So whenever you feel you have some questions while you are listening to the three speakers speaking, you can write down your questions at the chatting the area in the middle of lower part of this Zoom conversation part. And then we will collect these questions at the end of the three speakers' speech and try to deal with as many as possible and raise this question to the older participant. Okay, thank you. Let me start with a short introduction of three speakers. Today we have very excellent speakers. One from US, first Ernesto Falcon of Electronic Frontier Foundation, who practically authored 2018 California Net Neutrality Act that bans imposition of network use fees. Well done, Mr. Falcon. This was really impressive. And we have another speaker from Europe, Christoph Mertens of Bundesnetzagentur. Bundesnetzagentur. I hope this is remotely correct in my pronunciation.
Perfect.
Germany. And BEREC, which is a body of European regulators for electronic communications. Mr. Mertens was involved in 2012 BEREC decision that rejected European Telecom Network Operators Association proposal to charge network use fees. So he has done already important work on net neutrality, I understand. And the last speaker will be Professor Park Kyung-shin of Korea University Law School. And he is also a member of the steering committee of OpenNet, which is one of the co-organizers of this webinar. Let me start with Mr. Falcon. Floor is yours, 20 minutes.
Thank you. I'll go ahead and share my presentation here. One sec. Okay, do you see that screen? This has a net neutrality perspective from the US?
Yes, we can see it clearly.
Excellent. Okay, so as mentioned, my name is Ernesto Falcon. I'm the Senior Legislative Counsel at the Electronic Frontier Foundation, and I've been very involved both at the federal government level as well as within the 50 states, the debate over the regulation of our internet service provider industry, the question of net neutrality. And I'm going to give a little bit of a quick, a short bit of the history. But before I go into that, some background of who or what my organization is. We are what's called a public interest law firm, which is an organization that works within the court system on behalf of individuals who lack resources to defend themselves or to assert their rights. And the issue of net neutrality we see as an issue of freedom of speech, as well as innovation and the right to utilize the internet in an unfettered way, kind of making full use of the technology. Many of the founders of the Electronic Frontier Foundation, also known as the EFF, were folks who built kind of the original technology that involved the creation of the internet, and were also internet service providers themselves back about more than 30 years ago. So net neutrality really comes from this core concept of non-discrimination for purposes of the movement of goods, dealing, kind of with a history that dates itself back for hundreds of years. And our first, national universal communications infrastructure, which was our telephone system, following the telegraph system, operated under this concept of what's called common carriage, which is similarly interchangeable as a term legally with net neutrality. And about 30 years ago, maybe about 25 years ago, we went from a monopoly era of communications to invoking competition as part of our federal policy as well as our state policies. And this is just a representation of the breaking up of what was called the AT&T monopoly. AT&T was the name of our company, the American Telegraph and Telephone System. And our still foundational law that governs all of these issues federally at the national level is called the 1996 Telecommunications Act, which amended our communications law. And this is a little bit of just these points here are the history that went into that law. And if you think about where these industries used to be and where we are today, the internet itself was kind of in its infancy still. This was still at a time where we thought more about information through newspapers, television, and radio, and not so much from how we do things today, which is social media, how we are communicating now, over video channels. And when the Congress created our communications infrastructure law, the core of it was the idea that there were services, kind of core infrastructure components, what we call the telecommunications service, that handled the transmission of the information, and then there were the components of that service that connected that network and utilized that network in order to reach consumers. And so we separated those in two categories. We called one the telecom service, and the other one what's called the information service. The telecom service was the common carriage system, which, as I mentioned earlier, is kind of interchangeable with net neutrality and the idea of a free and open flow of communications required by law to ensure non-discrimination. And then information services were the services that rode over that common carriage system. And federally, within our federal system, the telecom service is the regulated party and the information service the unregulated party. In the early years when the broadband system started becoming online, the position of the US was that system should be free and open, that you should be able to connect to whatever devices you wish, that you should not be hindered in any way of making full utilization of that infrastructure. And then in the years that followed, in the early 2000s, there were different problems that came up. My organization was very involved from the engineering team of assessing what the internet service provider industry were doing with people's information, ways they were interfering or blocking, and would issue reports that were used in litigation as well as in the regulatory space. And this is just a history of events that have occurred over the years, indicating a constant tension between content providers and technology companies. At the time, companies like Google were actually much smaller. They really were still seen as the new company, a new entrant, a disruptive force, but not necessarily where they are now, which is a very large concentrated industry within the technology sector. And then in 2008, President Barack Obama asserted very clearly that he, as president, wanted to make sure that the regulation of internet service providers was clearly net neutral, was clearly something affirmed in the regulatory space, in the regulatory law under the 1996 Act. And through many years and many court challenges, that law was that rule for net neutrality for the U.S. was solidified in 2015, really kind of reconfirming past precedent in this space dating back decades prior. So it wasn't that they invented something new, but more just modernized it, updated it, and applied it to the internet. And we're successful in any challenges that happen in the courts. Some of our largest internet service providers, Verizon and Comcast, they're the names. They were the two primary litigants in, I would say, the major court cases in this space. And one of the major issues that caught the public's attention about the issue of net neutrality was this issue of interconnection and connecting between providers who sent information over the internet to consumers and the access point consumers relied on to see that content. So in this instance, it was a fight between Netflix, which is a very large now today a very large video company. Actually has a decent amount of Korean content nowadays, but they distribute here in the United States. That was running into this situation, what they call the terminating access monopoly, where lots of part of the U.S. market have very few choice for internet service access, and Comcast was one of the largest of those players in terms of a monopoly position with consumers. And they were routing their traffic in a way that degraded the video and would request from Netflix that they would then transfer funding to pay them to alleviate the congestion. And the congestion in this instance was actually caused intentionally by the incumbent, by the cable company, the internet service provider. So, the Federal Communications Commission, our primary regulator, in 2015, as part of net neutrality, asserted that the federal regulator will oversee, not necessarily intervene and set out rules yet, but oversee the behavior in this market where content and ISPs have to exchange information and kind of shake hands and make an agreement. This chart kind of indicates the kind of the history of what was happening when the two companies were at dispute. Suddenly, during the dispute, the content was degrading from Netflix, and then when they reached an agreement where Comcast would be paid money by Netflix, the congestion was alleviated shortly thereafter. And that was concerning for regulators because moving information, particularly in this market, was getting cheaper, not more expensive. And so, to the extent that the ISP asserted that they needed to be compensated for the movement of information from a video provider, the video provider, in this instance Netflix, was actually investing a lot of money in their own infrastructure to reduce the cost of delivering that data for the ISP. So low, and this is old data. This is 2014, but by their estimate, for an hour of video costed the internet service provider about less than a penny, and was dropping, reducing in price every day with the advancement in technology. Yet they were being asked to pay hundreds of millions of dollars. So as I kind of reiterated these, why did the FCC create the 2015 Open Internet Order, which is our probably the seminal, the most straightforward net neutrality rule federally. A lot of it was lack of competition, lack of choice in internet service providers, as well as addressing many of the troubling behavior that happened in the years prior. And also this belief that as long as the internet is maintained open and the barrier of entry to move information was as low as possible, that you engage in what's called the virtuous cycle, where ISPs would gain customers because the internet would have value to users who would then subscribe to more ISP services. In exchange, more people would invent products over the applications and services, which then would continue to keep driving more interest and more value in the internet. Today in the U.S., the internet is seen as an essential service. About 3 out of 4 Americans consider it as valuable to them now as water and electricity. And it's really raised in the importance of how the public perceive access. And in recent years, the previous president embarked in more of a deregulatory path on the assertion that regulating these ISPs has resulted in their unwillingness to invest in the infrastructure. Much of these claims are disputed even to this day. And when the new FCC repealed net neutrality, it sparked a protest all across the country. Is one of the most participated in, commented on federal actions in history in our country. This is the number of entities. We have thousands of businesses. Lots of people make a living creating content on the internet now to share with people and monetize it that way. And millions of people wrote comments through the comment system we have with the FCC, vast majority of them in opposition. So, we get to the federal system no longer applied in terms of enforcing net neutrality. And I, as an advocate and as a telecom lawyer in the space, had to think about what are the options then if the federal system won't institute these rules and enforce these rules. We have to rely on our 50 state governments. And so we have, EFF, my organization resides in California, which is the largest state in the nation in terms of the economy, 5th largest economy in the world, by itself. And so to have the state itself at least regulate the internet access of net neutrality within the state of California would actually has a pretty sizable impact on the nation, simply because of the size of our economy, and the need to comply with one of the states tends to drive compliance with the other 49 to kind of mirror that compliance, rather than rather than operate two different systems or two different approaches. And so, we set out to simply replicate the federal rule that existed under the 2015 order with state law, and there's one of the more interesting points of debate was this issue of zero rating. So at the end of 2016, this is the previous president, so President Barack Obama, at the end of his term and at the end of his administration, they were signaling through staff investigations and regulatory investigations that zero rating, the practice of establishing a data cap with your wireless service and then choosing other services that you also sell. In the instance for AT&T, which was one of our big wireless players, they also own content, and they were essentially saying, if you use our content, it won't cost you any extra money. It won't cost you any overage fees, and it doesn't count against your data cap. You're restricting your total allocated amount of data you can use with our service. But if you use other services such as Netflix, or such as in this, today we have Disney offering the second, one of the second largest, I think, streaming services today. If you use those services, it will cost extra. And so we took the findings of the FCC at the end of the Obama administration, which was that type of arrangement violates our 2015 Open Internet Order, and took it one step further to clarify and take those findings and establish it as state law immediately. And that was probably one of our biggest sources of debate in the state of California. The picture here, this is Senator Scott Wiener. He's a state senator who helped EFF to draft the state law, along with Professor Barbara Van Schwevik from Stanford, and to advocate and to go through the process. And it's a little outdated. I forgot to update this line. The bill has been signed into law. I have it set here as that is awaiting signature. It actually has been signed into law, and we've been in the courts now. And this is effectively what the law is. Fairly short. You take a very large 100+ page set of order and regulation and try to condense it down to its component parts. In a state law, this is essentially what you kind of break it down to. And the basic premise of net neutrality: no blocking, no throttling, no impairing a lawful content. And towards the C4, 5, and 6, we get at the dispute between content providers and ISPs, as well as the interconnection debate, as well as zero rating and the prohibition on what we call discriminatory zero rating, where you apply zero rating policy only to favor your own products, but disfavor products of your competitors. It is worth noting that zero rating is allowed in certain instances and really only at the user's discretion. So if I, as a phone user, tell the company I would like to have my cloud backup system to operate at a lower bandwidth so it doesn't count against my data cap, I'm allowed to make that selection as a user and decide which services can do that. That's allowed still, but for all intents and purposes, most other forms of zero rating are not. And we've so far been successful in litigating this in the courts. We've won the first important round in the challenge, and there's a second challenge happening now. I think by the end of this year, you'll see if the state of California is given the authority to continue its effort here. But however, what's happening at the same time is we had another change of presidencies. The new president was our current President Joe Biden, was the vice president of President Barack Obama, who brought forth the 2015 Open Internet Order. And so for all is a strong assumption that the new president will simply at least pick up where his previous partner and predecessor established the law, established the regulation, and will go further. So we expect a return to the federal rules, but we still have to fight whether in the courts whether we can have the state continue its ability to regulate in the place of the federal government in parallel. And when California was successful at the first round of litigation, because they were challenged by the internet service providers on the legality of the state to do this instead of the federal government, once California won that first round, AT&T, which is the company engaging the practice that the Barack Obama FCC from 2016 found that the behavior likely appeared to violate net neutrality, discontinued the practice that was explicitly meant to be banned by the California law, which was holding out its video service, which was called HBO Max or HBO Go at the time, or in an earlier time, and no longer establish a structure where if you use some other video service, you have to pay us more, and if you use our video service, you don't have to pay us. Likewise, they cannot go around and require other video content providers or any any service to pay them some sort of fee in order to be exempt from a data cap, give them a special privilege. And I think at the core of this, why do the carriers even engage in zero rating? We are entering a stage in the infrastructure, particularly with the advent of 5G and the deployment of fiber optic wires, where there's great abundance in the data and the cost of moving data is dropping rapidly. So why do we need to have any sort of scarcity? And this is from the ISP's own findings and their own surveys, but they filed with our regulator. But it really comes down to the fact that they know CTIA represents the wireless industry in the quote here, that when they establish an artificial structure where certain parts of the internet cost nothing extra to use and other parts cost more, that users will be kind of shaped and forced into using the free products or free in the context of they don't charge an overage fee. They still pay a fairly high monthly bill for access, but they don't pay an overage fee on top of that. And so there's a great amount of power to be had when you could establish where the internet is free and costly and where it's not. And so this is, kind of what the driving force behind the decisions do this. And to this day, the issue of pay prioritization and being paid extra money by the ISP to get favorable content is still a major concern, primarily driven by many of our small companies who are afraid that they cannot engage in that type of pay to play system, where, especially in today's market, where when you have Google and Apple and Netflix being multi-billion-dollar capitalized companies, sometimes in the trillions range, far capable of engaging in that type of discriminatory behavior and establishing dominance in the market, as a result of that approach. And another issue that resonated in California to do our regulation on zero rating was the findings in the European Union. So in the EU, this is from a study by Epic Center Works. They studied for a handful of years the difference of wireless pricing when you had zero rating and what happened when you banned zero rating or removed most zero rating from the equation. And ultimately, what they found is the countries without zero rating had the cost of wireless service drop. And I think that makes sense if you break it down as to what happened, which is when you can't force consumers into overage fees and charge kind of hidden fees, you actually lower the overall cost of what happens to their bill in terms of the internet usage, because they no longer are trapped in these overage fees. So this is where that study is. It's worth a good read. It also talks a lot about how companies cannot engage, small companies, internet companies cannot engage in zero rating. And we are still proceeding in California litigation, and one of the big issues still remains public safety. One of the catalyst moments in our state in the debate was the fact that our firefighters had their information throttled during a national state emergency. The Verizon company had which is one of our telecoms, had a data cap on public safety instruments, which then were throttled and disabled during a statewide fire. And why does it all matter? And I've mentioned this in the last time I was privileged to speak before many of you here. But it really comes down to the freedom to exchange knowledge and information, and continue to advance our knowledge collectively as by having the advantage of being connected to one another. And so this is just a quick recap of where we are in the U.S. And I'm happy to answer any questions. Thank you.
Thank you. Thank you, Mr. Falcon. That was really a great talk with a lot of information. And also raised some very important questions. I understand that the situation in California and indeed in USA is different from South Korea, but this issue of zero rating is also a big issue here. And I'm sure the Professor Park is going to talk a little bit about these issues. But I also want to mention that your data on the internet cost of different countries, whether they have a zero rating or not, is really illuminating, because I have to say the many internet service providers in South Korea claims that zero rating is used mainly because they wanted to provide a better service for the internet users. So I think what you just mentioned, introduced, is really significant for our future discussion. Thank you. Thank you very much for your talk. Okay, our next speaker is Mr. Mertens. Floor is yours.
Thanks a lot. I'm trying to share my screen. Just a second, please. So I hope you can now see my screen. Can you?
Yes. Thank you.
Great.
We can see you.
Well, I will start. Well, I will hear today. First of all, I'm really happy to have the opportunity to participate in the event and to share the experiences across the world. And we think that it's really a truly international issue we are discussing today. And my task now is to present the European perspective. Mostly, I work with the German regulator, which is Bundesnetzagentur, Federal Network Agency. I'm working there as an economist. But I'm also engaged at BEREC, which is the body of European regulators for electronic communications. And BEREC in the past has worked quite a lot on issues related to IP interconnection, as well as issues on net neutrality. And here on this first slide, I just try to show what we have done in the past. You can see that many of these papers seem to be pretty old, but when I prepared myself for this event today, I noticed that our findings, they are still valid today. And I think that's really a good signal. What am I trying to show today? It's first, we as BEREC first try to better understand what are the differences between the telephony world on the one hand, so to speak, and the internet world on the other hand. What are the charging mechanisms in both worlds, and what are the differences, and what are the implications from these differences? And as you can see, I will briefly also address the mechanisms of transit, peering, paid peering, which are the major mechanisms in the interconnection sphere. And then I come back to the ADNOC proposal that was already mentioned today from 2012, where we as BEREC sharply criticized these ADNOC proposals. And I finally have a look at how interconnection disputes and practice look like. But let me first start with a closer look at the telephony world. Here in the, I'm just saying telephony world or let me just use this term, telephony world, so to speak. And here we can observe that at the retail level, we have a system that is called calling party pays. So when I call someone else, I will be paid for the whole call. It goes from the sink to the from the source to the sink. And this system of calling party pays is pretty familiar in Europe. And the underlying assumption is that when I start a call, the assumption is that I'm the prime beneficiary and that I cause actually the cost of that call. And the corresponding system from this, the corresponding system to this calling party pays at the retail level is calling parties network pays at the wholesale level. This means there is a payment flow at the wholesale level from my telephony provider towards the telephony provider of the person I'm calling to. And the fundamental issue is that ultimately this implies that given that the terminating provider has a termination monopoly, that provider under CPNP is entitled to receive a payment out of his position. And the implication for us as regulators is, well, we finally have to regulate the termination monopoly. So this means the system of calling party network pays creates a need for regulation. And of course, I mean, regulation is never an end in itself. It would be preferable to let the market forces work, but given that there is such a termination monopoly, there is also a need to regulate this termination monopoly. And this obviously creates a lot of costs for all parties involved, for the providers, for us, the regulators. So the transaction costs of regulating are actually, they are significant. And the last bullet point here on this slide says the payment flow equals the call flow. And this means, as I said, with calling party pays as well as with calling party network pays, the call goes from A to B, and in the same direction, the payment flows go both at the retail level as well as at the wholesale level. So this is very much the way the telephony world works. In the internet, it is very different. Here we have at the retail level a system one I call receiving party pays. But to be more precise, when I pay my internet access provider, I make a payment for receiving as well as for sending data. And at the wholesale level, we have a system that is called bill and keep that is applied for the terminating segment. And higher up in the network, we have these mechanisms of peering and transit, which are applied upstream in the backbones. So you can already see that there are fundamental differences between the telephony and the internet world. Let's have a closer look at this idea of bill and keep. I think there is an early paper from, I think, Patrick de Graabe, a former FCC economist, who I think it was in the late 80s or early 90s, wrote a fundamental paper on bill and keep, and he really carved out what the merits of this system is. And bill and keep actually is a wholesale billing regime where each network bears the cost of terminating the traffic that comes from other carriers. And the fundamental issue is that under bill and keep, there are no payments made at the wholesale level for the termination service that is provided. And as I said before, bill and keep is applied for the terminating segment. And this idea or this principle of bill and keep applies regardless whether there is peering or transit. But just to avoid a misinterpretation, bill and keep does not mean that there is a zero price. It is true, there is no wholesale payment, but nevertheless, when network A traffic is terminated by network B, yes, there is no payment from A towards network B, but nevertheless, network A incurs some costs, which is for providing the network capacities for terminating network B's traffic. So no price at all at the wholesale level is not equal to saying there is a zero price. each party bears the cost of establishing the network. And for us as regulators, it is really fundamental that this idea, this principle of bill and keep implies that there is no exploitation of the physical termination monopoly. The termination monopoly as such is still there, but the terminating network provider is under bill and keep is not entitled to receive a payment for this termination service. And we think that it's really remarkable that with the system of bill and keep that is applied in the internet, there is no need for regulation like in the telephony world. And so the system of bill and keep really has some economic and efficiency advantages because there is no such need for regulation. And we felt that is really remarkable. And when discussing proposals, say whether or not to implement sending party network pays in the internet, one should always look whether this might even create a need for regulation. Currently, there is no such regulation for the termination monopoly in the internet. On the other hand, in the telephony, there is a need. These are fundamental differences. Let's have a quick look at the mechanisms of transit and peering. As I said before, transit and peering, these are the mechanisms that are applied higher up in the network, in between network backbone provider and between backbone providers. And transit implies that there is a payment between different providers, and transit also provides full connectivity to the internet. With peering, it is slightly different because peering does not provide such full connectivity, and there are different flavors of peering. And peering can be open, can be selective, can be restrictive, or a provider may even say, well, I'm not peering at all. And but this is really up to the provider for the provider to decide which peering policy he applies. And typically, the peering requirements, or what are the peering requirements, issues that are relevant are the traffic ratios, the traffic volumes, capacity, geographic reach, and so on. And very often, providers would not come to a settlement-free peering agreement with another provider when the traffic ratios would be completely unbalanced. But it's ultimately a decision of the peering policy of the providers, and if the other network that wants to peer with me fulfills my peering requirements. And the principle of settlement-free peering, where there is no exchange of money flows between the providers, obviously has some advantages because there are no transaction costs no transaction costs are involved. There is no need to measure the traffic, and but nevertheless, there can also be on a paid peering, there can also be payments with peering agreements. But maybe a quick look at the diagram that I used here on this slide, and I just want to illustrate with this graph that here in the internet, payment flows are upstream. I as a network, say I'm the autonomous system number 5. On the left-hand side, at the bottom, I pay for upstream connectivity. But what is paid for? I pay for traffic flows in both directions. As you know, I already said that in the telephony, the payment flow goes in the same direction like the telephone flow. Here in the internet, it's different. The payment flow is not equal to the data flow. When I try to wrap up these findings, maybe the most important thing is that under bill and keep that is applied for the termination monopoly, we have no possibility to exploit the physical termination monopoly. That's a huge benefit of bill and keep. And also transit and peering agreements, they are in Europe typically not regulated. And as you may know, here in Europe, we have a net neutrality regulations for roughly 4.5 years now. And I think the fundamental principles of this open internet regulation are pretty similar to the principles that are applied in the United States, as we have just heard. But the issue, I have to explain it a bit better. We as BEREC, as European regulators, we provided guidelines that the aim of which is to implement the provisions of the European net neutrality regulation. And we want to make sure that across Europe, we as European regulators implement these rules in a similar, in a consistent way. That is why it's fundamental for us as European regulators to exchange views and to understand from each other's experiences. And ultimately, we want, with a consistent application of the European net neutrality regulation, we want to promote the internal market in Europe. In our BEREC guidelines on this open internet regulation, we do not practically address the issue of interconnection. And we said in our BEREC guidelines that NRAs may take into account the interconnection policies and practices of internet service providers insofar as they have the effect of limiting the exercise of end-user rights. But as such, interconnection is not regulated with these open internet provisions of the European net neutrality rules. Only if an interconnection policy would circumvent these open internet regulation, then we might have a closer look. But as such, interconnection, it is closely related to net neutrality issues, and there are some overlaps, but nevertheless, conceptually, one should try to really distinguish between these issues, but never, as I said, nevertheless, there are close or let's say certain overlaps between these issues, but we may come back to this issue in our discussion later on. Well, we have already heard about these ETNO proposals from 2012. It seems to be pretty old, but what happened in 2012? ETNO, which is the European Telecommunication Network providers organization, they ahead of the World Conference on International Telecommunications, ETNO made some proposals, and they wanted to implement a reference to an internet charging mechanism, sending party network pays into these ITRs. And when we as BEREC looked at this, we ultimately heavily criticized these proposals that were made by ETNO. Why? We felt that if we were to implement this logic, this rationale of sending parties network pays to the internet, it would ultimately mean to use the mechanisms of the telephony world and to apply them to the internet, which, as I said before, does not know a termination monopoly. And we felt it would be very strange to implement the old telephony mechanisms to the internet. And we said this would lead to a risk of shifting the balance of negotiating leverage between market parties, and even more important, it would create the risk of abusing the termination monopoly. Such a proposal to implement the sending party network pays principle in the internet would induce a need for regulation. I think it's really remarkable if telco providers call for a system that requires regulation. Typically they argue, well, we don't like regulation. But here it looked very much opposite. And another argument why we were so critical is that we felt that there are some underlying assumptions with these ETNO proposals that are not really correct. The first point is, it is the end users that cause the traffic. They request the content and they pay for this traffic. It is not the content, the CAPs, the content and application providers that cause the traffic. It is the end user, and he, the end user, pays. And the further issue is, we as BEREC, we felt that there is no evidence for a free riding behavior and practice. We felt that the proposals made by ETNO assume, at least implicitly, that certain players along the value chain get a certain service for free, and in competitive markets, is it really realistic assume that a party gets a free ride? Typically, we always say it's conventional wisdom, there is nothing like a free lunch. And last but not least, we said both sides, CAPs and the IBOR ISPs, they are mutually interdependent. As content providers, your content would be worthless if there are no networks. It's a trivial thing as such. And in the other perspective, of course, if you have a good network, the network would be worthless if there is no interesting content. Both parties are dependent on each other. So ultimately, we as BEREC heavily criticize these proposals. Finally, and I will try to come to my last remarks. When we looked at the generic nature of IP interconnection disputes in practice, we noticed that traffic asymmetries are an important factor. And of course, we know that with streaming, the traffic asymmetries, they have grown in the past. And typically in such disputes, Ernesto already referred to these disputes between Netflix on the one hand and the eyeball ISPs. We felt that each party blames the other parties for having caused the problem. And from the outside, it's very hard to decide whose fault it is actually. And of course, each party has certain strategic considerations and motivations. But ultimately, we could observe that such disputes are typically solved in the market without regulation. And we felt that overall, the market forces work pretty well. So as I said, basically, interconnection is not regulated. Of course, it requires a closer look whether things change in practical. But at the time when we wrote our papers, we could observe that overall the markets do work pretty well as such. And finally, the question is ultimately which side depends more on which side? Is it the content providers that do depend more on the eyeball, or is it just vice versa? That is really a key question. And I think, well, I covered most of my things and I'm happy to discuss. Thanks a lot for listening.
Thank you very much, Mr. Mertens, for your really dense and full of really nice arguments. I particularly like your way of distinguishing the important question of who should pay into two different, the telephone communication and internet. And you, I think, give a very good reason why we should keep the net neutrality, because each end users are already paid for their services, and they actually requesting this content from the content provider. And also you gave various other good arguments, but I find that particular argument is very persuading. Thank you very much. I'm pretty sure that Professor Park is going to talk about the Korean situation, which will be related to the BEREC, the proposals and the U.S. California's situation. Professor Park, floor is yours.
Yes, thank you. I want to use my time two different ways. I'll be a discussion for the presentations made by Ernesto and Christoph, and also I'll make a short presentation of my own. So the first part, I'll do it in English so that the presenters, so that Ernesto and Christoph can understand clearly what my questions are. The second part, the presentation, my presentation, I'll do it in Korean. So Ernesto, Christoph, if you want to hear my presentation in English, you can press the interpretation button on the Zoom call. So now the questions first. To Ernesto, if you look at the screen right now, there is a provision in the law that you drafted. And if you put together the phrases, it comes out to this sentence. It shall be unlawful for ISP to engage in requiring consideration, monetary or otherwise, from an edge provider in exchange for delivering internet traffic to and from the ISP's end users. If you can explain to the Korean audience what this sentence means, I'll appreciate that. Maybe you can just do it now if you want, or you can do it later. And then I'll also, then I have a question for Christoph. Ernesto, would you like to do it now or later?
I go ahead and answer it now, if that works. This really is kind of both addressing this concept of pay prioritization in terms of two ways. So there was two ways that we were worried about how ISPs would extract their dominant position. One was pay us some sort of fee for priority treatment, or in other words, reducing the quality of other services that are similarly situated, and you'll be the one exempt from that. So that's traditionally how we think about pay prioritization, this idea of giving one special actor priority treatment. This is of a similar vein, but more on the premise that simply requiring the edge provider to require them to pay the ISP just simply to be accessible, to be on the internet, and we would call this more of an access charge. And it's broadly worded because it's not just about payments of money, but the work consideration in the U.S. is fairly broad. Essentially, any sort of arrangement or exchange of value that is valuable to the company or to the companies beyond just finances, beyond just money. We just simply do not want the ISP to engage in a practice where they can simply go to companies of their choosing on the edge, as we call the edge provider. Really represents your internet companies, your services, your applications, and to be able to leverage their position to simply ask for a payment in order to be connected to the customers of that ISP, simply because that doesn't make a lot of sense. The customers of the ISP are asking for those services, not quite the other way around, where it's the internet company asking to be connected to the ISP. So the demand is driven by the customers who pay that ISP already for that service, that they're compensated for delivering that connectivity, and so for them to essentially engage in a second stream of revenue after already being compensated for delivery of the information, delivery of the data, involves a lot of dangerous discriminatory policy, that discriminatory action that net neutrality really is the heart of preventing.
Okay, great. So what you're saying is even before this law was written, you had a concern about paid prioritization, but this provision is more fundamental in a sense that, for paid prioritization, yes, ISPs will require money for delivering something faster than others, but there is even a situation where ISP will require money for delivering content at all, right? Making it accessible at all. And you wanted to just ban that. You just wanted to ban, set up a broad ban for requiring that kind of payment. I guess when you said that consideration the consideration that's banned can be not just monetary or otherwise, when you say that, it made me think that maybe this broad provision covers zero rating as well. Although you have specific provisions on zero rating, this provision can also cover zero rating, because if ISPs charge content providers for participating in zero rating, that means in the market, ISPs will basically make the paying content providers' content more accessible to the users because the access will not be credited against the data caps. So that's kind of also one way of making the access, expanding the access of a certain content provider in exchange for money. Okay, if you don't want to add anything there, I'll move on to my second question, Mr. Mertens. In your, are you there?
Yes, I'm there.
Yes, yes. So I wanted to ask you whether so I can see that BEREC is very fundamentally against charging for delivery of data by ISPs. And SPNP is that type of system, basically charging for delivery of data. But how about paid peering? What's your position to that? Because as far as I understand, paid peering, a lot of times the payment is not for volume of data delivered, but a lot of times for capacity of the connection. Although I mean, I don't have all the numbers, so I don't know how many of them are capacity based and how many of them are volume based. But what's your position to with respect to paid peering as opposed to data delivery fees?
Well, I mean, that's really a very good fundamental question, and I'm meaning that because paid peering, I think it's really a complicated issue. First of all, paid peering is not prohibited by any rules or something like that. In practice, it seems that paid peering gains relevance. In the past, most peering agreements were done on a handshake basis. Roughly 99% of all peering agreements were simple handshake agreements. But now, with the growing traffic asymmetries, providers tend to prefer paid peering rather than making settlement-free peering arrangements with other parties due to these traffic asymmetries. And as I said, I mean, paid peering is not forbidden, but still we can observe that very often paid peering is applied when larger eyeball ISPs are involved. And you referred to the differences between data termination payments and paid peering. That is correct. But from what is most striking for me, being an economist, I think, and I'm saying I'm not having the perfect answer, but when we're able as an eyeball ISP to say, okay, you want to terminate me, you want that I terminate your data traffic that is coming to my network, to my providers, to my end customers. And if I just say, okay, I will increase my interconnection capacities, but it costs money. This is ultimately, even if there is bill and keep, if there is no possibility to exploit this termination monopoly, this would ultimately be very similar, because I could say, well, I want money. I will increase my capacities, but it costs you extra. And it might give the eyeball ISP a certain degree of bargaining power. And nevertheless, I said paid peering as such is not forbidden, but when we look at this issue, I said that the relative bargaining power between the caps on the one side and the eyeball ISP, which side depends more on the other side, that is really fundamental. If I, as a gatekeeper, as an eyeball, are able to, say, extract excessive rents for paid peering, then we might have a problem, even if otherwise we have bill and keep. So again, I'm not having the definite answer, but I'm saying that paid peering can create problems. It's not necessarily the case. And a final remark is that we, as European regulators, we do not have a look into the glass bowl of interconnection, so to speak. This means most of us European regulators do not have monitoring rights. We just see the black box of interconnection mechanisms, and we think it roughly works pretty well. There are some disruptions, but more or less it works. One exception is ARCEP, our French colleagues, the French regulator. They have monitoring powers, and ARCEP could actually observe that in practice, paid peering has gained relevance. For us, for the other NRAs, it was more a finding from the literature and conventional wisdom because streaming gained relevance, but ARCEP looked into the glass bowl, so to speak, of interconnection, and they could observe that paid peering becomes more important. And it remains to be seen whether this creates problems that ultimately require regulation or not. I'm not having the answer, but this may be the case.
Okay, thank you. I think hearing your answer, I do understand that although paid peering at a certain moment will be maybe a fair arrangement between parties over a long period of time, if ISP continue to request money for expanding the capacity over a long time, it can look like SPNP. So I guess your concern is paid peering, although by itself is allowed, it is open to abuse over a long period of time. And
yeah, absolutely.
Maybe the reason France can afford to allow paid peering is because they have they collect all the data on interconnection, because they can closely monitor what's going on and act when there is a risk of abuse. So, okay, thank you. Okay, then I'll start my short presentation in Korean. So we can all look at the screen together. 예, 이제 우리말로 시작을 하겠습니다. 예, 한국에서 쓰는 그 망이용료라는 개념, 즉 망사업자가 콘텐츠 제공자의 데이터를 망사업자의 고객들에게 전달한 대가를 콘텐츠 제공자로부터 받는 그 데이터 전송료로서의 망이용료 개념은 전 세계 어디에도 실행된 바가 없습니다. 메르텐스 씨가 소개를 한 것처럼 2012년도에 유럽 망사업자연합에서 그런 제안을 했었지만 그 BEREC, 유럽통신규제기구로부터 신랄하게 비판을 받고 포기한 바가 있고요. 그 포지션 스테이트먼트가 여기 있습니다. 영문으로. 저희 홈페이지에 올라왔으니까 보시면 되고, 메르텐스 씨가 이 입장문을 쓰는데 관여하신 분입니다. 여기 보시면은 그 인터넷에서는 그 데이터 전송에 대해서 돈을 받는 것은 그 인터넷의 전송 방식에 완전히 반한다라고 얘기를 하고 있습니다. 그리고 그 방금 전에 어네스토 펠컨 씨가 얘기를 한 것처럼 그 캘리포니아 망중립성 법에도 이미 망이용료 받는 것을 금지하는 조항이 있고요. 이게 어디에서 온 거냐면 이미 2015년도 오바마 정부의 망중립성 명령에 이것도 이제 홈페이지에 있습니다만 113번에 보면 그 고객들에게 망사업자 고객들에게 어떤 컨텐츠 제공자의 데이터를 전달한다고 해서 컨텐츠 제공자로부터 돈을 요구해서는 안 된다라는 내용이 있고 그 내용을 법조문 조문화한 것입니다. 그런데 우리나라에서는 이 전송료로서, 그러니까 데이터 배달료로서의 망이용료를 명시적으로 역시 허용한 개념은 없었는데 지금 허용하는 방향으로 가고 있어서 매우 걱정이 됩니다. 그래서 2016년도에 발신자 종량제를 망 사업자들 사이에서 실시를 하기 시작했고요. 그리고 2020년도에는 컨텐츠 제공자에게 데이터 전송에 대해서 책임을 분산시키기 시작했습니다. 근데 2016년 발신자 종량제와 2020년도에 그 컨텐츠 제공자 서비스 안정화 의무법을 합쳐놓으면 어떤 결과가 나오냐면 결국은 데이터 전송이 제대로 되도록 컨텐츠 제공자가 돈을 내야 한다. 즉, 망 이용료를 내야 한다는 그런 결과가 나오게 됩니다. 그런데 2021년도에는 처음으로 입법 문서에서 전해섭 의원 법안에서 입법 취지에서 통신망 이용료라는 그 개념을 언급을 합니다. 결국은 이 통신망 이용료의 내용, 통신망 이용료 개념을 자세히 보면 결국은 데이터 전송료로서의 망 이용료를 의미하고 있는 것으로 보입니다. 이렇게 되는 것은 아까 그 캐바나 공사대리께서 말씀하신 것 중에 규제를 어떻게 하느냐에 따라서 한국의 컨텐츠가 해외에 전 세계에 제대로 전달될 수 있는지 또 국내 소비자들이 해외 컨텐츠를 제대로 접속할 수 있는지를 결정할 수 있다 라고 하시면서 나라별로 이 인터넷의 규칙이 나라별로 인터넷에서 그 데이터가 전달되는 방식이 다르게 되면 이 인터넷이 깨질 수 있고 한국 컨텐츠가 해외에 전달되는 것, 또 한국 소비자들이 해외 컨텐츠 접속하는 길들이 막힐 수가 있다는 얘기를 했습니다. 그런데 이런 식으로 우리나라만 망 이용료, 즉 데이터 전송료로서의 망 이용료를 법제화하게 되는 것은 저희는 반대하는 것입니다. 해외에서 망 이용료를 징수한 사례가 있었다라고들 말씀하시는데 실제로 그런 경우는 매우 짧은 시간 예외적으로 있었다가 지금은 없어졌고요. 그리고 어떤 경우는 아까 그 메르텐스 씨가 말씀한 것처럼 페이드 피어링의 사례들입니다. 그 전송료로서 망 이용료 사례가 아닙니다. 프랑스 사례가 많이 얘기가 되는데 프랑스에서도 아까 말씀드린 것처럼 페이드 피어링을 허용을 했던 것이고 허용했던 것이지 전송료로서의 망 이용료를 허용했던 것이 아닙니다. 프랑스에서 페이드 피어링을 그렇게 허용하는 이유는 상호 접속 계약에 대해서 모든 조건들을 프랑스 규제기관이 전부 다 수집을 해서 계속 감시를 하고 있기 때문에 페이드 피어링을 상대적으로 허용을 하는 것이고요. 근데 우리나라는 지금 발신자 종량제가 있기 때문에 지금 페이드 피어링을 허용을 많이 하게 되면 결국은 발신자 종량제가 컨텐츠 제공자에게도 부과되는 그런 상황이 발생을 하게 됩니다. 인터넷은 새로운 표현의 자유의 세계를 열어젖혔습니다. 표현의 자유의 경제적인 문제를 해결해 줬습니다. 옛날에는 수많은 사람들에게 메시지를 전달하고 싶으면 엄청난 전화비나 엄청난 우표값을 걱정해야 됐는데 인터넷을 통해서 더 이상 사람들은 그런 걱정을 할 필요가 없게 된 것입니다. 지금 실제로 보면 어떤 상황이 벌어지고 있냐면 인도네시아에서 지금 서비스 컨텐츠 제공자 서비스 안정화 의무법과 비슷한 그런 비슷한 법이 지금 인도네시아에서 통과가 됐습니다. 그래서 지금 한국 컨텐츠들이 인도네시아 망사업자들한테 돈을 내야 되는 상황이 발생을 했습니다. 물론 인도네시아는 발신자 종량제를 하지 않기 때문에 한국처럼 심한 분쟁이 발생하지 않을 것으로 보입니다만 이게 바로 그 캐바나 공사께서 말씀하신 것처럼 어떻게 전 세계적으로 이 망이용료를 받는 상황이 발생되면 어떻게 한류의 발전에 드디어 문제가 발생을 할 수 있는지를 알려주는 사례가 있습니다.
박 교수님, 지금 오디오가 잘 안 되는 것 같아요.
예.
지금 다시 괜찮습니다. 네, 말씀하시죠. 그리고 비디오는 꺼지고요. 화면 공유는 꺼졌습니다.
Yes.
발표 끝나신 건가요?
예, 끝났습니다.
Okay. Okay. I didn't know he is finished. Okay. I think what Professor Park gave at the end of this, we actually almost finish off our promised time. And since we do not have any questions yet, I wanted to just sum up our discussion today. And if there is any question while I'm talking, then we will answer this perhaps the first and the last question of this webinar. I didn't. Okay. I think what Professor Park said was very important in the sense that I was worried that we covered a lot of net neutrality issues as well as free flow of information, but I thought that we didn't actually cover the last part of our webinar title, which is the Korean-US data trade. But Professor Park mentioned that this issue of net neutrality and the kind of regulations the Korean National Assembly is proposing to implement is actually influence a lot on the data trade between the different countries. either inward or outward, meaning that it will influence the data flow of so-called Korean culture exporting to the other countries, as well as when Korean internet users are looking at various contents from the foreign countries. If this new regulation is implemented, it will actually restrict various ways the way we use and communicate data through internet at the international level. And so that's why we have this connection between net neutrality and data trade, as well as flow of information. I don't know about you, but I learned so much from this seminar, and we actually see through the situation of net neutrality in US and in European countries and in South Korea. And although we do not have enough time to discuss this matter further on this occasion, I hope that we will have this fruitful interactions between these three regions of the world on the issue of this net neutrality in the future. And I really want to thank that the co-organizers of this wonderful event, including the Chumi-san of OpenNet and Chun-Mi-rim of HY CELPST, but most of all three speakers and I think he's gone now, but all three speakers and Mr. Cavanaugh for helping us to have this wonderful event. Professor Park, would you like to say one more thing before we finish?
Yes, because of what you just said. Yes, we didn't get to cover the trade aspect of it fully, although you yourself covered a little bit. I wanted to add just one more aspect to that. Right now, the CP Service Stabilization Act, 이건 저기 한국에서 더 필요한 건 한국말로 하겠습니다. 지금 그 서비스 안정화, CP 서비스 안정화 의무법이 그 조문을 잘 보면 CP들이 CP들에게 데이터가 그 ISP의 고객들에게 제대로 전달될 것에 대해서 책임을 묻고 있는데, 이 CP들이 국내에 들어와 있는 CP들만이 아니라 모든 CP들에게 적용되게 돼 있어요. 그럼 예를 들어서 트위터나 어떤 한국에 서버가 없는 CP들까지 전부 다 이렇게 적용을 받게 되면 결국은 트위터 접속에 문제가 생기거나 그렇게 되지 않도록 하기 위해서 트위터는 뭘 해야 되냐면 결국은 트위터도 서버를 국내에다가 만들어 놔야 됩니다. 캐시 서버를. 그러면 결국은 소위 그 데이터 로컬라이제이션, 서버 로컬라이제이션, 어떤 서비스를 제공할 때 반드시 국내에 와서 해야 한다. 이거는 이 FTA나 WTO에 위반되는 그런 규제가 되는 것입니다. 네.
I think we have a question now. But she didn't finish the sentence. It says the Korea is net neutrality policy and America, and it stopped. So I don't know whether we should go on. I think since we promised to finish at 3 p.m. In Korean time, unless other speakers, Mr. Mertens and Mr. Falcon, had anything to add at this point, I think we should finish here and try to have one more larger meetings where we discuss all these things in more depth in the future. Is it okay to finish now, Mr. Mertens and Mr. Falcon?
Fine from my side, and
Sure.
most of all, thanks a lot for the organization. Perfect. It was really an honor to present our views and to participate. Thanks a lot.
Thank you. Thank you for all. Okay.
Yeah, thank you again for having me here. I always appreciate the opportunity and the opportunity to learn.
Yeah, we really enjoyed your talk, both of you, and Professor Park's nice summary and the questions. Thank you, and have a nice day in your own region of the world. Bye-bye.
And thank you all. Thank you for all the achievements, Christoph, Ernesto.
Yeah, thank you for all your achievements as well. Yeah. Bye-bye.
Bye.